Hello, everyone, and welcome to Privacy Chats with Rachel and John. Today, we have a very, very special guest, one of our colleagues, David Greene. David Greene, if you'd like to say hello.
Hello, I'm David. Yep, I work with John and Rachel. Just as a quick introduction, I began my career actually in information security, where I worked for a couple of years. And then because of my passion for privacy and, viewing it as very important for society, for myself, for our future, I made the jump over to privacy about 2.5 years ago. So I've been working in privacy and I've really taken to it and I want to make it a career. So I'm really happy to come and discuss privacy with John and Rachel.
Nice. And
Nice.
question, just still, I guess, is a little icebreaker. Besides ours, of course, do you have any favorite podcasts that are in your rotation currently?
I listen to podcasts sometimes, normally when I'm driving, like on a long drive. There's a podcast called The Stuff They Don't Want You to Know. It's kind of like a conspiratorial podcast.
It reminds me of Adam Ruins Everything. Is it like the same vibe, sort of? Do you know who I'm talking about?
Not super familiar, no.
That was more of a TV show, right, Rachel?
Yeah. Or he did YouTube, whatever. Sorry, David, go ahead.
Oh, I know what you're talking about now. I do. Yeah, I did see the Netflix Adam Ruins Everything. But the stuff they don't want you, I'm certainly not super conspiratorial, but they just bring up interesting topics. And I think they just have a good crew that has good conversation. And actually, when I was driving from California to Colorado, which is a 2-day trip, I listened to the podcast the entire time. So I guess
Wow.
I do the podcast. Yeah.
That's funny because one of my go-tos is Stuff You Should Know, like a whole different one that I like, but I'll have to look out for that one. Could be interesting.
Yeah, definitely.
Well, I'll share mine then. This is going to be very generational, so bear with me. Do either of you recall the show Ned's Declassified School Survival Guide?
No. That's
Same reaction from David.
Yeah,
I know. I'm reverse aging myself here, but TLDR, they were all child actors at a time where I was pretty close in age. So I was watching the show and it's a how-to guide for middle schoolers to avoid all the mistakes that are so embarrassing and funny. And it was a little comedy that was on Nickelodeon, 15, 20 years ago. And now they're all like 30 something and they're just hanging out in LA being still actors and stuff. And they just basically took the model of the show, which was, guiding middle schoolers through school. And now they do it as adults. So it's fun, refreshing, not, super serious or anything, but gets me through my dog walks in the morning.
I love it. Well, I'm going to try and get us on track here because we're supposed to be talking about privacy stuff.
I got us on our icebreaker.
Well, that's good. Yeah. So, what are we talking about today? I think we've only got one person from California. So why don't you introduce our topic here, David?
Sure. Yeah. And I was a California resident for almost my entire life, well over 30 years up until about a year ago. And so I do have familiarity with the what we're going to talk about today, which is California privacy law. So in particular, CCPA and CPRA. So I personally was involved in both of those by, going to the polls and voting on them. I'm not sure, how you guys typically begin this conversation, but I kind of just wanted to give a little bit of background just on my, some facts and opinions about California in general and its, posture for privacy, if that's okay with you guys.
Yeah, keep going. Roll into it. The
floor is yours, man.
Yeah. So, California is a really big state. I'm sure, as you guys know, especially, with all the transplants moving out, one of the biggest states in the country for sure. It's got a population of about 39 million people. If were its own nation, it would be the 5th largest economy in the world. And so there's really a lot of things we could say about California, about its astronomically high cost of living, the politics, the history. But I think that one thing we in this country can all really appreciate about California is its contributions and its commitments to privacy. The concept of privacy is actually a part of the state's constitution. And I wanted to kind of just read that little section there of California's constitution. It says,
I didn't know that.
It says, all people are by nature free and independent and have inalienable rights. Among those are enjoying and defending life and liberty, acquiring, possessing, and protecting property, and pursuing and obtaining safety, happiness, and privacy. And that was added to the Constitution, I think, in 1974. Okay. So in this sense, California historically has been you know, one of the most privacy forward states in the country, you know, easily passed the most privacy legislation. And it really has set standards that have been adopted globally. So, you know, I don't want to take up too much time with my California spiel, but I do just want to say that, you know, California really has been a privacy leader, not just for, you know, California residents, but for the US as a whole. And it does affect everyone, right? Because laws have really changed the way companies do business. And you know, going back to California being the world's 5th largest economy, if companies want to do business in California, they have to comply with California state laws when it comes to data processing. And given the scale of California's economy, of course, companies are going to want to do business there. You know, if it was maybe like North Dakota, people might just not do business in North Dakota, but because you have California's economy and they want to do business there, they're going to, you know, and a privacy standard, treat all data in the strictest sense. You know, yeah, that's my intro to California.
I think, yeah, thanks for that tee up of the topic. And so just to, I think it's interesting, would you say that was added to the California Constitution in 1974? Yeah. So Rachel and I previously talked about some history of privacy. And if I'm remembering correctly, FERPA, which is a privacy law in education, I think was passed in 1974. I also think that the privacy, I think it's called the Privacy Act, which governs how the US government uses our, you know, private records and stuff like that. I'm pretty sure that was 1974 also. Yeah. So makes me wonder what was happening in the country in 1974. And I think it goes back to the dawn of the digital age. Like that's when, you know, not the same computers that we use today, but digital processing of data was starting around about that time. So I'm thinking it's probably related. I don't know. Do you have any recollection of some of those conversations, Rachel?
Yeah, I was thinking actually in the same vein about the FTC's fair information, like practice principles, I think developing around that time. So like agencies were taking hold of these new expectations. And I know in the discussions of in the history in Europe, like the OECD was starting to develop some guidelines for automatic processing and stuff. So like the 70s, 80s, really pivotal area, and that it lines up, I guess, with the wake-up call the world and legislators were seeing at that time with the technological advancements we were seeing. Cool. Okay.
So David talked about two different things. So this gets a little bit confusing. So we started off with the CCPA, which is the California Consumer Privacy Act, which was passed in 2018 and went into effect in January 1st, 2020. Then in 2020, there was another ballot initiative passed in November 2020, which was the CPRA, the California Privacy Rights Act, which was essentially an amendment to the CCPA. So combined now, it really is the actual law that's on the books is CCPA as amended by CPRA. But I think that when most people talk about it today, they talk about CPRA, and probably because that's what's top of mind, because that's the thing that companies are now coming to terms with of the new one. So many things to say. I wanted to link that into GDPR and the timing, but let me ask this as a question, just to see what you guys think. Why was it necessary to amend a law that had just gone into effect? Like, do either of you have any opinions or insight into that?
I had to, in all fun fact, the CCPA was actually my first work exposure to privacy. I was doing consulting at the time. I had learned a little bit about privacy in my undergrad, but I wasn't really sure how it played out in the working world. And I was working with a subject matter expert on the CCPA for clients in California at the time, even though I didn't reside there. So that was like the first door opening. So I have a little special place in my heart for this, but I wasn't as familiar with, because I did have to at least get familiarized with the CCPA at the time. I wasn't sure what the CPRA had actually reintroduced. So I had to do a bit more personal research on this, honestly. And first, another sidetrack here. The CPRA is already an acronym used in California legislation. There's also the California Public Records Act. And while researching, I actually saw one of the sites parentheses that CPRA acronym instead of CPRA in the sense we're talking about. So a little goofy, oopsie, funny thing there. But as far as I had absorbed, there were new rights that were introduced that weren't necessarily not included in all cases in the CCPA, but maybe were either assumed or implied by those that were involved with the initial draft creation of the CCPA that didn't quite make it into like what ended up being the legal interpretation for those same requirements in practice. So it sounds like a little bit of going back and doing some red line work to say, okay, here's what we're missing. Here's what we need to define a little bit further. The most interesting piece, I think, of this, and I know we're going to bounce around a little bit in the areas of the CPRA, but I thought it was really interesting that there was intention to include, what is this called? Cross-contextual behavioral advertising as a form of sale, in the sense that it should have been included as a disclosure for, individuals to understand what their data was being used for and the ability to opt out. And it didn't sound like the way that companies had responded to the CCPA, they really took that approach. So that was one area that I found is a bit of an improvement or clarification there. I know that there were additional rights included, like the right to know about automatic decision making, which I believe is also incorporated in GDPR, if I'm remembering correctly as well. So I'm seeing parallels to this, right? Or am I confusing something? I see your eyebrows scruffling a little bit.
I'm wondering if, I don't recall that being a specific part of, although real nerd here, I have GDPR up at my desk. But I don't think that it is. I'm going to look it up while we're talking. But one of the most significant additions that I noticed in it was the creation of the California Privacy Protection Agency, which didn't exist in the original CCPA. Which creates this actually very well-funded agency that is in the future will be responsible for enforcing these measures. So far, it looks like they haven't done a whole lot, but I think they need more time to pass. Like they've appointed members and they've issued press releases at Greene with different things and issuing opinions about stuff. But let me go back to the fact that, because David, you said you had to vote on it. So, we often think about legislation as something that is passed by legislators, and we as residents don't get to participate in that process. So that's a little bit different in California, that it was really the people who chose this, right?
I think so. And, I guess one of the things that really sticks out to me about CCPA and CPRA is that it really is consumer oriented. It's really designed to protect, users from business practices. And so, as you mentioned, I did have the opportunity to vote on that. Obviously, before I was even involved in privacy, data privacy. So when I saw it on the ballot, I was actually completely unfamiliar with it. And I know that I was telling Rachel this when we were at dinner. When I did go to vote in for CPA, when you go to vote on the ballots, it shows you kind of the for and the against positions. And I think, you're going to be pretty hard pressed to make an argument for why Californians shouldn't vote for additional privacy measures. And so they made sure to note in the opposition that the proponent for the main leader for CPRA was a multi-million-dollar net worth real estate developer. And they're kind of trying to sell you on this idea that actually he didn't have your best interest in mind. And this was actually going to harm California. And obviously that wasn't a winning argument, and it certainly passed, but it was certainly an interesting argument against. And of course, the opposition also had a slew of big tech companies that I think were also in support of opposition to CPRA. Obviously, they're not going to go too hard on it because that probably wouldn't be great PR for them. But yeah, I think California and privacy have certainly it's gone hand in hand.
I mean, that opposition makes sense, considering that the businesses that are in scope, of course, are any that do business with California residents, regardless of whether you're based there. But there are, annual gross revenue requirements, minimum of, I think, 25 million, and either, collecting a lot of information on California residents or at least profiting from them. I think it's, you have to do business with 50,000 or more, or like half of your revenue needs to come directly from, selling personal information. So I can see why certain organizations are going to be a bit more sensitive to these types of proposals.
Of course. And I know we're probably gonna get into all the details of the law, but The thing that really sticks out to me for how CRPA affected CCPA is that concept of sharing data. So when CCPA was first came out, it was around selling your data. And so while it increased the threshold for the amount of users data that you had to be dealing with from 50,000 to 100,000, it also added that not just selling data, but sharing data about users. So, and if you go down the line, that's one of the biggest changes to each piece of CCPA was not only is it selling data, but data that's been shared. So I just wanted to point that out as what I see to be like the most glaring effect of CRPA.
Yeah, and well, jumping around a little bit again, I know we wanted to talk about both the enforcement history in the past and like what the fine structure is, but Sephora, I think Sephora, our makeup cosmetic company, was the first, I believe, to be fined either the hefty amount or fined in general under CCPA because of that interpretation of selling versus, I don't think sharing was actually included in the CCPA its original form, but they viewed that the literal interpretation of sale, meaning you're getting money in exchange for giving data or vice versa. They didn't believe that was taking place because they're transacting in cookies or browser data, and it doesn't actually involve any monetary reward or incentive or financial gain either way. But that ends up being the result if advertisers really value this data very highly. And, Sephora benefits from that increased partnership and traction and probably from receiving data as well. So that was I'm skipping ahead a little bit, but that really calls out to your mention there of sale versus sharing and how there was a different opinion from at least the public to initiate this ballot that companies ultimately didn't interpret, or at least their legal departments didn't interpret as selling.
Yeah, I was looking at, as I was looking for resources for this discussion, I stumbled across the State of California Department of Justice. So this isn't just talking about CCPA or CPRA enforcement actions, but there was I think there's others, because some of these were, the state of California combined with other states to, go after companies for, larger things. So it was probably violation of like the FTC Act or something like that. But some of them are quite interesting. The one that stood out to me the most was there was a case for Aetna, which is a finance company, right?
Insurance provider.
Insurance, right? Because it's medical. It's related to medical stuff. So their thing that they were, I don't know, found guilty of, I guess. They sent letters to 1,991 California residents, which this is a quote, revealed through an oversized window in the envelope that recipients took HIV-related medications. So it was really a mistake that the company had bad envelopes, and because of that, you could see through the side of the window that something about the subject matter of the content. And they were fined. Let's see if I have it here. Aetna was almost $1 million, so $935,000. I'm not sure where they come up with that number from.
Yeah,
but
sure, a drop in the ocean for them, but it's not to say that it doesn't count as a violation, right? Even if it is on accident. So you have to have the safeguards and controls in place. In this case, probably a little harder because it is manual and paper stuff, but good reminder for us all.
Yeah, and actually, just to back up a little bit, Rachel, just to tell you that you were right. So GDPR Section 4, Article 21 is the right to object and automated individual decision. It's automated individual decision making, right? So kudos to you.
Well, CPRA didn't pull it out of thin air then. Did you find that just by searching through your book? You didn't. I mean, you don't have
just the table of table of contents.
Okay, I was going to say that's impressive.
But back to GDPR. So on the timeline, so GDPR went into effect around about 2018. I think it was passed in 2016. It was passed in 2000. No, 16.
No, 16 then 18. You're right.
Okay. So really the same timeline. And, we've talked before about GDPR is really kind of the gold standard and the template that a lot of other countries and jurisdictions are following. And, you could look at CCPA and now CPRA and see a lot of GDPR in it. So it goes back to that whole thing of like the world is kind of falling in lockstep of enforcing the same practices together.
Yeah, and toward steering the rights to be focused on the users, the consumers, instead of being, just kind of caught in this crossfire of data sharing and unintended consequences, but actually giving the ability for us to remove data from platforms, to request correction if it is inaccurate, to request to know where my data is going. And I think that's only fair, considering that not always do individuals get the same scale or the same, benefits at large that companies do by having our information outside of, completing transactions. So, but to your point earlier, David, with, companies that kind of deal in this data brokering, data sales, data exchange, having a large focus on things like the CCPA, and having the fact that consumers are advocating for it, going to the polls, going to the ballot to push these changes through. I personally don't feel like this pattern will slow. I think the fact that the U.S. is very state-driven in its legislative processes in a lot of ways, and how we're very sectoral based on the national level, the requirements that will crop up in other states, I think Utah, Colorado, and who was that? Virginia, a few others are creating their own, state level privacy laws and considering these rights. I think what I would expect, my prediction here, is that these concepts will translate to the states where their, government in a very general sense kind of agrees with this position that California has, which is focusing on the user and the consumer. There are a ton of other incentives out there. There are a ton of other factors that I know play into the role of proposing and passing legislation, but I think it'll just depend on the attitude of the state at this point, unless we get a omnibus privacy law at some point.
Yeah. You guys can correct me if I'm wrong, but I do believe it's 5 states currently have comprehensive privacy law: California, Colorado, Connecticut, Utah, and Virginia. I think those are states that have it in effect now, but there will be, I think there's other states. I think
there's 6 more coming this year, and then others like teeing it up for the future. Yeah,
exactly. Yeah. And I guess one thing I noticed with, and I'm sure we're going to see this continue with privacy law, and we've experienced this on the job, I think the 3 of us, is that oftentimes privacy law can be very vague in how it describes, describes something like, what is personal information or what is user data. And I know that was one of the big changes from that CPRA implemented, was just a more defined and specific criteria for what falls under user data. And even though California is comprehensive privacy law, it's the GDPR is still a little more broad and strict over what data falls under GDPR versus what falls under CCPA. I think that's a pretty big difference between CCPA and between GDPR, because CCPA actually only applies to for-profit businesses. It wouldn't actually apply to nonprofits, whereas GDPR applies to pretty much any entity that's processing data. So California, being the beacon of capitalism, certainly the law still focuses around business. And I mean, it really is almost a discussion for another day when it comes to the competition between privacy and business. And I know that we all here are certainly privacy advocates. You still have to kind of respect the fact that places like California even are beacons of innovation, creation, where many of our products come from that really impact our lives. And I have to kind of at least give a little bit of credibility to the corporations who are saying, hey, when you pass these laws, you're really going to stifle our ability to innovate. And this has actually happened back in 2012 when Kamala Harris was the AG for California. She actually had she put together a group. They were called the Privacy Protection and Enforcement Unit under the Department of Justice. And they were, even as early as 2012, because obviously 2012 was sort of when this kind of newer tech boom was underway. Google, Facebook, Microsoft, Amazon, and they really this group really did track behaviors of tech companies, follow up on discrepancies, and I think that's when some of these tech companies kind of came out and said, hey, like, this is actually going to harm California. This is going to harm the economy. This is going to harm jobs. So again, that's a conversation for another day. But yeah, certainly there is a competition between privacy and innovation and productivity.
It's a good point, and I wonder, like, clearly the pendulum is swinging globally towards tighter privacy regulation and more fines and protection of data. But typically a pendulum's going to swing too far before it comes back the other direction. And right now it feels as if we're in the direction of it's certainly going stronger. I don't know that we've crossed the threshold. I think businesses in California would say we've probably gone too far. I think there's probably a lot of companies throughout Europe that might say that we've gone too far. But others don't agree. Max Schrems, for example, is he's hardcore on
made his whole career out of the NOYB.
Yeah, I mean, he started out with just like didn't he do like a paper or something in college to start, like a homework assignment or something?
Very grassroots sounding, yes.
Yeah, but listening to him talk, he's saying that there should be more controls, tighter controls, more fines. But he's also made his whole career out of it. I don't know. What's your opinion about that? I'm gonna go back to you, David, on that question. Do you think we're going too far yet? Like, you don't still live in California, or do you?
I do not live in California anymore. I live in Colorado now, which also has comprehensive privacy law, which I certainly
see it on another episode.
Yeah. And my opinion is, I wouldn't say that we've gone too far. What challenges me though, and I work for a very large company, so we have tons of resources to throw at problems like privacy problems, tons of resources, tons of money. But it does kind of cause me to reflect on, smaller companies who don't have the resources that a larger company has. And when they come up against privacy law, violations, and they're not able to investigate or, rectify issues as well as a large corporation, it seems like they're going to be the ones who are punished the most, much more so than companies like, the big tech companies that can pay these fines, can, hire huge legal teams. So in that sense, I can't speak to how it impacts small businesses, but I think that's where I'd be more concerned, is how it's affecting small businesses versus corporations.
Yeah, I think when I was reading through, I don't have specific notes about this, but when I was reading through the text of CCPA as amended, so includes the CPRA stuff, there was definitely some sections in there with exemptions. Am I saying that right?
Yeah.
And I think it was clearly the intent in those exemptions, or some of the exemptions that I was reading, was to protect small businesses. That if you're, they need to be able to survive in the same world as the big Amazons and Microsofts and stuff like that. Yeah. So yeah, hopefully.
And exemptions for industries or companies that fall into industries that are already covered by existing federal privacy-esque laws. For financial information, you're already covered by GLBA. If you're already covered by HIPAA, there are some exceptions there. So yes, both for businesses and the scope of the business. To me, that leads me to believe that privacy by design is that much more important. If you are a small tech company intending to scale, it is much better as far as like investment cost, and your return on that investment to, lost my ear, to start with your program incorporating privacy in your design practices, in your testing, your QA processes, and creating those safeguards as new features or new products are created under your suite. And that's where I'm excited about actual privacy enhancing technologies to give us the capabilities that we don't want to sacrifice, even if it is for a reason as great as privacy. We still need data to do a lot of research. We just still need data to understand what your personal preferences are to see content. We need personal data to facilitate transactions, and transactions will take a far different form in the next 10, 20 years as things get more convenient, as logging into accounts become lower touch, connecting with others becomes lower touch and takes a slightly different form than we're used to. So that's my spiel, I guess, on the small company stuff.
One of the things that I noted in here that I thought was interesting is, and this is covered in a lot of laws, they have a section that deals with where there's conflicts between this law and others that might already be on the books. So in CCPA, amended by CPRA, their section on conflicting provisions basically says that the regulation with the greatest protection of privacy wins. So if CCPA, CPRA has the best privacy protection for consumers, then it supersedes the others. But if there was already a law on the books that offers more protection to people, then that one supersedes, which is interesting because usually those provisions will pick one or the other. But this one just says, you know what, we're not going to pick one. We're just going to say the one that with the greatest provision, the greatest protection for consumers, as they're called in this, or natural humans, as they're referred to in GDPR, wins, which I thought was interesting.
Right. I'm interested, John, because you had mentioned that you looked at a few examples of maybe other violations besides Sephora, which was obviously the probably the most covered in the media that we all came across. But I'm interested to hear which stories that you came across in your research.
So, yeah, I talked about the one for Aetna with the envelopes, the wide envelope. There was a few others. So there is a provision in CCPA, CPRA about having good like cybersecurity practices for companies to protect the personal data. So there's a couple of these from the state of California Department of Justice about weak security practices. Anthem was fined $8.69 million for weak security practices. Primera Blue Cross, $10 million. Uber, $149 million for a breach cover-up. So it wasn't for the breach itself, but it was because they tried to be sneaky and not tell anyone about it. Cottage Health Systems, $2 million for weak data security practices. Other interesting one, Wells Fargo was fined $8.5 million for recording consumer phone calls without disclosure.
Oh, so, yikes.
Just right. And I'm sure it was, just for, well, I mean, who knows why they were doing it. There's another company, Aaron's, which I guess rents things to people, and part of what they rent are computers. And they were fined $3.4 million for effectively installing spyware on laptops that they were renting to people. I'm not sure what they were trying to accomplish with that. Last one I'll talk about was, Kaiser Health was fined $150,000 because a USB key was found in a thrift store, and it had unencrypted data on it with employee records for 20,000 employees. I'm assuming Kaiser Health employees, but somehow all of that data got put onto an unencrypted USB key and just left in a thrift store.
Oh.
So,
yeah. Secure your stuff, people. But I am hearing that it's a combination both of obviously ignorance, but then maybe a little bit of poor decision making on how to handle things. But there's also like a flare of, it can be an administrative misstep, can also create, the opportunity for fines. When I was looking up some of the, fines or enforcement lawsuits against CCPA, provisions, a lot of the ones I saw were about not notifying really users accordingly, based on they're very simple mistakes. It's almost like, you don't take that first step to really look into what you need to add to your privacy program in order to be compliant. We're not putting complete notices, not, omitting important information from those as in how to exercise your rights under CCPA. Not, including the do not sell your personal information opt-out. And even just for, if there was one about a mobile app gaming company where it failed to ask its 13, 14, 15-year-olds for explicit permission to sell their personal information, which sounds weird when I say it out loud, but I mean, it does need to be explicit when it's minors, right? And there are, I think, you're opening yourself up to greater fines, I think, especially when you are in the business of perhaps children as your consumers. So it can be a simple oversight. It can be negligence. It can be a little bit of, I don't know how far that data breach cover up one is necessarily ignorance or what. But yeah, it's just about following the steps and doing your due diligence against what's provided to you in the law.
It's true. Yeah. And I think that, I think the point is that a lot of this is new to a lot of companies, and I think a lot of companies are just assuming that these privacy regulations are going to be something that gets handled by their cybersecurity department or
like their marketing department. I'm hearing that privacy can rest in a lot of different, especially smaller companies with less overhead to invest in a full-fledged privacy program. Like it can sit in a lot of different places, and these these teams within companies can be very siloed. So that lack of understanding, communication can harm you later when you have to respond to something as quick as a 6-month, 1 year, 2 year, even grace period.
Yeah, but I think that like the point there is that they're putting it as an additional responsibility onto somebody, and it it really can't be. It needs to, like, companies that have to comply with these regulations, and even that if they don't, if they like should be doing the right thing to protect people's data, protect people, needs to be a dedicated function within those companies. So
if you want to do business with the largest economy in the world, right, David?
Yeah, definitely. And sorry, there's one other point I wanted to make before we moved on real quick, just because you were talking about the which company was it, Rachel, the video game company you were referencing?
I don't have the name of it. This aggregator didn't actually disclose the company that was in violation, but they did list some of the general, missteps companies have made. But do you have one in mind?
No, because I think that's just one thing that is obviously really important to me. It was strange because I'm pretty sure when you're that young, I think you mentioned 13 and 14-year-olds, I thought you had to have parental consent, like the parents had to approve sale of data. But one other, I know we're talking about CRPA and CCPA, but California does have another law specifically oriented towards minors called the California Age Appropriate Design Code Act that's coming out. This was passed in September 2022, and I think it's going to be effective in July 1st, 2024. And so this act prohibits certain advertising tactics that are directed at children that can be detrimental to their health, profiling children for targeted advertising, and using dark patterns designed to encourage children to disclose personal data. And I don't know if you guys have done or planning on doing a discussion about dark patterns. That's probably one of my more interesting topics. These sort of UI layouts that make it more difficult, for instance, to remove information about yourself or remove credit card information from your account, or make it more difficult to delete
or opt out of emails. Don't get me started on that. I'm like, oh.
Yeah. So I absolutely appreciate I certainly feel like legislation aimed at preventing harm to minors is in regards to abusing their data is super important. So I really do appreciate California coming out with that one, and it's super pertinent to that company you read reference, video game companies, because these guys are the biggest culprits. You have stories of kids spending tons of money on their parents' credit card accounts
without knowing, because of the design. Just doesn't make it intuitive. I did that on a game that is partially targeted toward children. This is another sidetrack, but my friends and I play Fortnite. Yes, I'll say it. But I had purchased something without knowing it, and I was like, oh my god, this is what that lawsuit was about. And here I am, at my age, not 13, 14, 15, falling for these dark patterns. So it's important for children, but then sometimes I think we need to raise the standard for design practices for everyone, because I'm not going to be an expert at every website and app I use, and I would trust that those that are experts in design can keep my considerations in mind while still giving me the option to purchase if I want.
Yeah. And as we've seen, when you have these big kind of precedent-setting, statutes and laws, it kind of spreads throughout, kind of globally, it gets adopted globally. So I'm hoping to see, places like California leading the way, kind of coming out with this legislation, and hoping to see it spread to other parts of the world, especially when it comes to data for minors.
Yeah, agreed. Actually, one of the questions that I wanted to cover, but I think we mostly did already, and some of the things you said, David, was why do I care about this if I don't live in California? And your point about that's where like a home base for a lot of these big tech companies is in California, like Silicon Valley, right? It's where we're famous for. And I remember it's kind of similar. I remember reading an article one time that talked about the influence that the state of Texas has on school books, like curriculum books in schools. And it's just because they're so large, like the state of Texas is so large, and whatever way that they designed the textbooks, so that if the state of Texas tells the book manufacturers you have to either include or exclude certain content from the textbooks, they just figure it's easier just to change the textbooks for the entire country and not just change it for the state of Texas. So because of that, the state of Texas influences education throughout the whole country. which is similar to California is enacting these laws that really don't apply in Colorado, but the companies that are operating in Colorado, because they also operate in California, have to comply, and they're just going to figure, well, we're just going to comply across the board, which I guess is easier, and I know they're not going to pay fines in Colorado, but the way their systems are designed and operated, for sure, are going to be similar.
And I personally, I'm of course biased because I do agree with a lot of the provisions added with the CPRA to the CCPA. But I think that's a solid compliance strategy if you have the means to do so, starting with the most conservative option for either, your largest population of users, or just to start there as your baseline to say, okay, the floor is the law, of course, obviously, but the floor is the law for any region of users we could serve. Then from there, looking at your business model, looking at, your appetite for risk, looking at, just basics of ethics and doing good business, like you said, avoiding those dark patterns, keeping in mind users' rights as an inherent right and not an option. I agree with that. I think that's an approach we should be taking, and these laws should only help. And I, hope it does spread like wildfire, like we're suggesting here.
Okay, well, this has been a long conversation. We keep saying we're going to try and make these shorter, Rachel, but we haven't succeeded yet.
Yeah, I think deep down, I don't want to, because I want to talk to you guys forever. But
well, right, and I know we could talk for another hour. But yeah, this was a great conversation. And thanks for joining us, David. This was awesome.
Yeah, well, thanks David.
Yeah, that was great. Thank you.
And for next time on the Colorado Data Privacy Act, we'll have you do with some more spiel. Yes.
Happy to.
Maybe some dark patterns.
I'd love to. Yeah.
Awesome. Okay. Well, thanks to our audience, our listeners, for listening, of course. Maybe watching if you're a YouTube person. No? Watching. And until next time, thanks for tuning in. Bye, everyone.
Bye.